As a citizen of the Republic of Kazakhstan, I, Kusman Kızı Saltanat, using the right provided by the Constitution of the Republic of Kazakhstan to declare that my rights, freedoms, and legitimate interests are grossly violated by the law through this letter to the honorable owners of the above-mentioned positions responsible for the execution of the Constitution. In 2005, while studying at the institute, I got a job as an assistant with Zhang Wei, a citizen of the People's Republic of China, the wife of the founder and director of SI Ltd. And Minmentals Kazakhstan. Subsequently, I was entrusted with the authority of an economist of companies. However, all orders and instructions on financial matters were under the jurisdiction of the spouse Zhang Wei. All money obtained from the sale of special equipment and other services goods was personally managed by Zhang Wei. She also independently gave orders on the distribution of funds for the purchase of special equipment, spare parts, and other expenses of companies. From the time of my employment for him, the staff took payment for special equipment in foreign currency. We were committed to the fact that we immediately handed over this cash to Zhang Wei, who had never been kept in the office after a series of thefts. The movement of cash, income, expense was reflected in the journal, which was conducted in Chinese, according to which Zhang Wei accepted this money. In connection with the illness of the founder and director in one person, since September 2014, Zhang Wei and her husband went to China for 15-20 days for treatment and later to Japan. In the interval, when they were not in the Republic of Kazakhstan, they instructed me to collect all the cash in the apartment that belongs to them, and which I received through the cashier of the company Davletxan Mulder, for which we did not accept to sign any documents as intended Zhang Wei. In December 2014, they went to Japan for treatment. During this period, by order of Zhang Wei, all the cash that came into the company was collected in a dressing room, from which she left me the keys for these purposes. The total amount of funds received through the journal was $510,350, some of which went to the expenses of the company at their own disposal, and the remaining amount of $430,000 was collected in their own apartment in a locked wardrobe. However, on January 2nd, 2015, there was a theft in the apartment, and only this money was stolen. I suppose by picking up the keys or having the keys from other regular visitors to this house. In addition, the spare keys of the house, as it turned out during the search, were located in an accessible place in the hallway. On this fact, I previously appealed to the deputy director and chief accountant of the companies. The deputy director replied that she could not come, sent the chief accountant at the place of the theft, who told me that the money belonged to the director and not to the company. In this connection, she told me to give such testimony. I even agreed to make an explanatory letter on my behalf in Russian, which I do not speak. March 16, 2015, Deputy Director Shakreeva and with cashier Nurmanbayeva brought me into the office fraudulently, asked to sign backdating payment and cash orders for a total of 77,400,000 tenge, with an indication at the exchange rate in the currency of $430,000 because of bringing the accounting documents in order for verification by fiscal authorities. Not understanding what was going on, I turned all the same to the lawyer with the questions that tormented me that it might be fraught with, after which they were addressed to the authorities. However, to this day no procedural decision was taken. Subsequently, using for specified warrants, both companies filed a lawsuit to collect the indicated amounts from me. In the counterclaim for recognition of expenditure and cash orders, void denied. Also refused to conduct accounting and technical expertise. Entered into force in March 2016. Not having money to pay the state duty to the cassation instance, I could not apply. As a result, not having achieved justice, faced with bailiffs who seized my mortgage apartment, involved in numerous lawsuits, criminal prosecutions of 5 ERDRs. I lost my health and became insulin dependent, made attempts to end my life, because those people who I fully trusted and who trusted me lied and continuing to use their money, corrupt schemes against me. However, later from the victim I became a suspect in 5 ERDRs and safely was sent to the court, even in the presence of numerous procedural violations. Today, once again making sure that justice is again on the side of the victims, there is a reason to believe that I will be convicted illegally and unfoundedly, since only 2 examinations were carried out in criminal cases, investigative and dactyloscopic, and charged under Article 189, Part 4, Paragraph 2, and Article 419, Part 2 of the Criminal Code of the Republic of Kazakhstan. Therefore, using this video, I asked the President of the country, the Head of Government, the Chief Justice of the Supreme Court, the Prosecutor General, the Minister of the Interior to assist in solving the case, taking into account the above circumstances, and in this case, take into account the fact that in this case, the matter does not affect only my personal but financial interests of the Republic of Kazakhstan. I'm ready to present all my evidence. Thank you.